David Rivkin, Jr. is an attorney with Baker and Hostetler's Litigation, International, and Environmental Groups, and has extensive experience in constitutional, administrative, and international law litigation, including national security-related matters. He also has worked in the Justice Department. Mr. Rivkin has filed Supreme Court and appellate amicus briefs in several leading post-9/11 national security cases, and is a frequent contributor and guest on national television networks.
Let me begin by pointing out that law indeed is not silent in time of war. Indeed, war is the most law-driven, rule-driven activity. If you're an enemy combatant, you are a legitimate target anywhere in the world 24/7. Who determines whether you're an enemy combatant? With all due respect to my good friend Bruce, this is an issue that is exclusively within the province of military commanders and the President as the Commander-in-Chief.
Do you believe that any detainee held at Bagram prison in Afghanistan is entitled to have any judicial review, even when they're under our custody in Afghanistan, through habeas corpus that the Supreme Court extended to Gitmo detainees through Boumediene, or are they just outside the universe of the law?
What matters actually is not what I believe. What matters is an Article-free court, namely the D.C. Circuit, and decisively rejected this view. And again, I want to emphasize that this is the first time in American history with this level of unprecedented judicial engagement. And if we live in the rule of law, Bruce, we have to take the answers from the courts whether we like the outcome or not.
Well, you're suggesting many of the questions are beyond judges, but I want to suggest to you, is it your view, and this is consistent with the rule of law, that any detainee held at Guantanamo could be circumvented in his right to habeas simply by shipping him to Bagram and say, well, maybe you got your freedom in habeas out of Gitmo, but in Bagram you have no rights, and we could detain them forever there, irrespective of what the court ruled with regard to their detention in Guantanamo.
That point was pressed home, Bruce, as you probably recall, in the oral argument. I vividly remember it before the panel of free judges in the D.C. Circuit. That view did not carry the day because, again, we have a very unique constitutional regime, and we're talking about a general proposition as the Constitution applies globally with regard to U.S. citizens. The Constitution applies with regard to aliens only when they're U.S. soil. Post 9/11, we put Guantanamo in a different basket, but by and large, actions by U.S. government overseas against non-citizens are not subject to the constitutional norms and are not enforceable by article-free courts. That's how things work. My question basically is this. Under your logic about bringing people to justice, can you conceive of any war where in all instances you would be able to go and arrest without putting undue risk to the SEAL team or any other team, an obligation to bring somebody back, but you can never use deadly force against even a person like bin Laden? Under even your own logic about the scope of authorization, bin Laden is responsible for 9/11. We cannot use deadly force against him, not as a matter of rules of engagement and whether he was surrendering, but just you basically said a priori we should have gotten him. Did I get it wrong?
No, you're correct.
I would submit to you that in no other war in human history has been this unprecedented level of political and legal attention to how to do things right. Even in regard to the so-called torture memos that have been, of course, very unpopular, I don't know of any country that would bother to ask difficult questions. Have mistakes not occurred? Of course they occurred. Fog of war, the most difficult environment in which to always be right. But there can be no other war I can think about where any civilized country has done better. Let me close by pointing out the danger. Once again, this is a different debate. It's not a debate about law. It's a debate about nature of military threat. We live in a world where a small group of people, very small, can inflict unprecedented levels of destruction and mayhem. Unless we understand that, And by the way, the job of any military establishment, the job of our leaders is first and foremost to protect the American people. If we're not going to appreciate the proposition, we're going to pretend just because we don't have tanks driving or planes flying and thousands of troops marching in lockstep on either side, but that is not the danger. We are forfeiting any basis upon which the government has came into being. So again, that is the threat we face. I think we approach it with care and dignity, and I'm frankly very proud of everybody who's been involved in this war. I'm also very proud of the fact we continue to debate those issues because, again, many democracies, including some of our good friends, tend not to debate them. Thank you.
I want to thank, once again, each and every one of these participants who have, I think, elevated the debate. So I do want to thank David Rivkin. Sterling performance that invites us to want more. Thank you very much.